It's Monday, so welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about marijuana arrests. Cases that should have gone to the Supreme Court of Canada, but didn't. The case of Tarek Lotfi is very interesting. He was pulled over by Constable Innes of the Integrated Road Safety Unit here in British Columbia, and in the course of his vehicle stop, Constable Innes detected an odor of marijuana and ultimately arrested Mr. Lotfi for possession of a controlled substance. A search of his vehicle revealed that he was indeed in possession of controlled substances. At trial, Mr. Lotfi argued that the officer violated his rights by arresting him for possession of marijuana when he didn't know whether or not Mr. Lotfi was entitled to have marijuana as a regulated or authorized holder, including somebody who might need marijuana for medical purposes. Mr. Lotfi appealed his conviction and argued at the Court of Appeal that part of the elements of a lawful arrest is that a person be considered to be in unlawful possession of the marijuana, and that because the marijuana regulations allow for authorized possession in certain circumstances, an officer must inquire about this prior to making the arrest. The Court of Appeal disagreed with Mr. Lotfi, and the Supreme Court of Canada declined to hear the case. But this case is very important, especially as we're transgressing towards legalization. This is a situation where many people are going to find themselves potentially being arrested for marijuana possession because it will be lawful to possess marijuana in certain circumstances and by certain individuals. Children, for example, will not be permitted to possess it, and people won't be permitted to have public possession of large quantities of marijuana. You can't drive around with bins of marijuana in the back of your truck just because it's legal. And so whether or not a person can be arrested for marijuana and whether that possession is lawful needs to be determined by the Supreme Court of Canada. And it would have been important for the Supreme Court of Canada to delineate the basis of an arrest where there's both lawful and unlawful possession of the drug prior to this issue becoming more complicated after legalization. It was an opportunity for the Supreme Court of Canada to get a jump on an issue that's going to make it back there once we have partial legalization of marijuana, and unfortunately they declined to do that. So for now, the law in Lotfi remains the law in Canada. A person can be arrested on the smell of marijuana and the belief that that possession is unlawful when there are people who are lawfully entitled to possess marijuana. This is going to lead to a lot of very bad arrests and a lot of very bad circumstances for people across this country. And I wish the Supreme Court of Canada had taken the opportunity to sort that out, thinking about what's coming ahead. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but Didn't. I'm Kyla Lee at Acumen Law Corporation, and thanks to Brazen Bull Creative for producing these videos.